All rise. Superior Court, State of California, County of Monterey, Department 17 is now in session. Judge Halsey presiding. Please be seated and come to order. Please silence all cell phones and refrain from talking.
Good afternoon, everybody, and welcome to the courtroom in the trial of the case of the people of the state of California versus Logan Gold, who is present and represented by the renowned defense team of Pacific Grove. The people are present, represented by the equally renowned team of Carmel. And ladies and gentlemen, I know that we have quite a few observers in the courtroom today. Regardless of which side you are on with regard to the pertinent arguments, I can assure you, having had these folks previously in my courtroom, if not this year and previous years, that you are going to be observing not only wonderful, zealous advocacy, but also you'll see the results of incredible work ethics, as well as the type of civility that we pride ourselves in here in this community. And with that, we do have a pretrial motion. It is the defense pretrial motion, but before we get started, would the prosecution team like to state its appearances for the record?
Yes, Your Honor. Good afternoon, Your Honor. My name is Scarlett Wennerholm, and along with my co-counsel, Julia Jackson.
Good afternoon, Your Honor.
And Brianna Shuto.
Good afternoon, Your Honor.
We represent the people of the state of California. And our witnesses.
Good afternoon, Your Honor. I'm Ali Sandival.
Good afternoon, Your Honor. I'm Taylor Alexander.
Good afternoon, Your Honor. I'm Riley Kim. Good afternoon, Your Honor. I'm Ray Forrest.
We're also joined by our courtroom clerk.
Good afternoon, Your Honor. My name is Dylan Shore, and I'll be serving as today's courtroom clerk. I will be providing visual and verbal warnings for 2 minutes, 1 minute, 30 seconds, and time has expired.
Finally, our coaches. Mr. Schreier.
Good afternoon, Your Honor.
Miss Morgan.
Good afternoon, Your Honor.
And Mrs. B.
Good afternoon, Your Honor.
And that concludes introductions from the people.
Thank you so much, Ms. Winterholm. And from the defense, would the defense like to state their appearances at this time?
Good afternoon, Your Honor. I'm proud to introduce the 2025 Pacific Grove High School Mock Trial Defense Team. My name is Matthew Wan, my pronouns are he, him, and today I'm representing my client Logan Gold for pretrial. May our attorneys now introduce themselves.
Please.
Good afternoon, Your Honor. My name is Grace Bishop. My pronouns are she, her, and today I'm representing my client, Logan Gold.
Good afternoon, Your Honor. My name is Yeva Yevdash. My pronouns are she, her, and I'm representing my client, Logan Gold. At this time, may our witnesses now introduce themselves.
Please.
Good afternoon, Your Honor. My name is Maram Haddad. My pronouns are she, her, and I am Logan Gold.
Good afternoon, Your Honor. My name is Noah Flynn. My pronouns are he, him, and I am Harper Duray.
Good afternoon, Your Honor. My name is Walter Schramm. My pronouns are he, him, and I am Cody Palmer.
Good afternoon, Your Honor. My name is Camille Walling. My pronouns are he, they, and I am CJ Costley. At this time, may our bailiff please introduce herself?
Please.
Good afternoon, Your Honor. My name is Ayana Yanis, pronouns she, her. I am today's bailiff. May our coaches please introduce themselves?
Please.
Good afternoon, Your Honor. Tom Morgan, attorney coach.
Good afternoon, Your Honor. Diana Rosenthal, attorney coach.
Good afternoon, Your Honor. Jenna Hall, teacher coach.
Good afternoon, Your Honor. Bill Hurst, teacher coach. Good afternoon, Your Honor. Mike Reed, attorney coach.
Thank you so much. And that concludes the introductions from both teams. Thank you. All right, this is a defense motion. So at this time, would the defense like to summarize the argument? The court has had the opportunity to review the authorities that you've presented.
On November 11th, 2023, my client, Miss Gold, was arrested for the kidnapping of Taylor Alexander. After being advised of their Miranda rights, Gold requested an attorney and was not interrogated at that time. Later, Gold's partner Duray arrived at the police station and insisted on speaking with Gold, who was allowed to do so only in the presence of Deputy Kim. During their conversation, Deputy Kim made comments regarding Duray's political position and placed their hands on their holster, applying pressure towards Gold.
Isn't this very similar to one of the cases that was cited in the briefs presented, Arizona v. Morrow in California, United States Supreme Court case in which, like your client, there was an individual who was in custody, whose partner came and sat into the interview room, and there was actually a tape recording of that interview, but the police were present, just like a deputy was present in this case, and the court found that there was no interrogation because it was simply a conversation, and there was no improper conduct warranting keeping the statement out.
Well, Your Honor, in Arizona v. Morrow, the law enforcement officer just simply stood in the room and observed the defendant. In our case, Deputy Kim stood close to my client and made statements toward my client telling them to tell the truth, and if they wouldn't, they would jeopardize their partner's position.
Well, can you go into perhaps a little more detail, or let's talk about the case of People versus Musselwhite. That was a California Supreme Court case in which you were talking about police conduct. In that case, the police not only led the defendant to believe that they had fingerprints, but they also promised leniency and told that defendant that they were not a suspect. So if your argument is that this case is different than Morrow because of the lack of police conduct in that case, clearly in Musselwhite, the California Supreme case, there was significant police conduct, and yet the court held that there was no coercion.
Well, Your Honor, in People v. Musselwhite, the police directly lied to the defendant by telling them that they had found fingerprints involving themselves. Well, whereas in our case, everything was truthful, and simply everything was truthful in our case. And when Deputy Kim talked to my client, while there's no questioning, they still made statements that implied questioning towards the defendant.
All right, you can go ahead and proceed with your argument.
Thank you, Your Honor. As Gold was not in a free environment to make voluntary statements without attorney representation, the statement, "I was trying to make sure that the family inn could be passed down for generations," should be excluded, as it was obtained in violation of Gold's Fifth Amendment rights.
What is the case that you want the court to take the closest look at? In other words, what is the case that has been presented in the authorities that you feel best articulates your position?
Your Honor, I would probably go with the case Brown v. Horwell, as in our case, Deputy Kim made comments about their partner's position, and since those comments were related to Deputy Kim's family, as Deputy Kim as Duray's Deputy Kim's spouse, and similar to Brown v. Horwell, in Brown v. Horwell, the officer told the suspect that their wife wants to see them, and that if they don't tell the truth, that they potentially cannot see their wife or their children.
And that is a Ninth Circuit case, correct?
Yes, Your Honor.
Which is persuasive authority, certainly for the court to consider. But why would the court follow the argument in the persuasive case rather than a case such as Morrow or Musselwhite, which supports the prosecution position that the statement was voluntary and that there was no coercion?
Well, Your Honor, while Brown v. Horwell is a persuasive case, its facts are very similar, as in the police in both cases did come up to the suspect and told them that if they were not to tell the truth, that they could potentially that they would either not be able to see their children, or in our case, they would jeopardize their partner's position. And while it's persuasive, some of its facts are very similar to our case. And I feel that when it comes to Deputy Kim's statements toward the defendant, telling them to basically tell the truth or else they will jeopardize their partner's position, I feel that that's a very important factor when looking at the totality of circumstances.
Can you talk a little bit about how the court should view Rhode Island v. Innes in this context? Because in that case, if you're talking about threats, the officers essentially were talking in a closed space, a car, so the defendant had to hear what they were saying, and they were talking about a child being able to find a shotgun that had been left at the scene. And the court yet found that the statements that the defendant ultimately made, leading them to the shotgun, were not a result of any coercive conduct.
Your Honor, Rhode Island v. Innes is not relevant to our case here, as in Rhode Island v. Innes, two officers were simply talking between each other. It was deemed as casual talk, as it was not directed towards the defendant. In our case, it's very different, as Deputy Kim was directly talking to the defendant, and also their statements implied questioning, and also implied that if they're not to speak up or tell the truth, that they could put their partner's position in jeopardy.
Thank you. Please proceed with your argument.
Thank you, Your Honor. Your Honor, you'll find in this case that first, Deputy Kim's statements constituted custodial interrogation, and second, Deputy Kim's actions constituted coercion.
You mentioned custodial interrogation. I don't think there's any dispute about the fact that your client was in custody, but there were no questions pending. The officer didn't ask any questions.
Yes, Your Honor. Though we have to deceive interrogation, because what constitutes interrogation is whether it would be reasonably likely to elicit an incriminating response from the defendant. And while Deputy Kim did not directly ask the defendant to say something, their comments telling them to lay everything out, as well as that they better tell the truth, and if not, they would possibly jeopardize their partner's position, were definitely designed to provoke a response. And that's why it would be deemed as an interrogation.
Thank you. You can go ahead and proceed.
Thank you, Your Honor. First, in Haynes v. Washington, the U.S. Supreme Court ruled that confessions made under coercion using psychological tactics or manipulation by law enforcement renders a statement involuntary. Additionally, in Brown v. Horwell,
well, Haynes v. Washington was even a pre-Miranda case, right? That was a case in which the defendant had been held for 16 hours and made a written confession after being told that he couldn't communicate with an attorney or his wife until he confessed. So wouldn't you say that that's quite a bit different than what we have in this case?
Yes, Your Honor. It is quite a bit different, as you mentioned, though it's important to look at what necessarily happened in the case. And there is police manipulation. And also that's same when we need to look at our case, because there was police manipulation as well. And in our case, Deputy Kim simply just did not stand in the corner and just watch the conversation. He actively engaged in the conversation and tried to provoke a response from my client.
And so, just so I'm clear, is it your position that urging your client to tell the truth is tantamount to the manipulation that the court found in Haynes, where the officer had the person in custody for 16 hours and wouldn't let them speak to their wife?
Yes, Your Honor.
All right. Thank you.
Thank you, Your Honor. Additionally, in Brown v. Horwell, the court ruled that appeals to personal relationships, such as referencing family, also constituted coercion. Well, here, in our case, Deputy Kim emphasized Duray's position and the importance of honesty, linking Gold's alleged actions as potential consequences for Duray. Additionally, Kim's conduct went beyond psychological pressure. By resting their hand near their holster, Kim sent a clear nonverbal message to Gold, leveraging Kim sent a clear nonverbal message of authority over to Gold, leveraging the psychological pressure.
And so there is a factual dispute here. I believe that your client and perhaps their spouse indicated that the officer may have had their hand on the holster. On the other hand, I believe it was the deputy's recollection that they may have placed their hand on their hip, but rarely do so. So are you wanting and or expecting the court to adopt your client's version of the facts in this case to settle that factual dispute?
Yes, Your Honor, as while Deputy Kim may think that he simply was resting his hands on his hips are for standard law enforcement, his hips are right near his gun. So looking at the defendant's mindset, the defendant could have misinterpreted it as him placing his hand right on his holster, as the hips are very close to standard law enforcement weapons.
Thank you, counsel. You may proceed.
Finally, Gold was confined in an 8 by 10 foot interrogation room, a setting very intimidating in itself. When combined with the actions and statements of Deputy Kim, it made it very clear that Gold's statement was involuntary.
2 minutes.
Secondly, Deputy Kim's statements to Gold constituted custodial interrogation. In the case State v. Finehout, the Arizona Supreme Court ruled that continued advice to a suspect to tell the truth after the right to silence had been invoked constituted custodial interrogation.
But in Finehout, and correct me if I'm wrong, the defendant had initially waived Miranda, then there was a second interrogation 2 hours later, and there were actual questions. There was police interrogation. It wasn't like the case with your client, where their spouse insisted on coming into the police station to speak with your client. It was law enforcement questioning, correct?
Yes, Your Honor. Well, I feel that would be important to look again at what the main point was between our case and State v. Finehout. And in State v. Finehout, the main thing we need to look at is the continued advice to the suspect to tell the truth. And that is similar to our case, as Deputy Kim's statements to the defendant were also designed to tell the truth, were provoked to the defendant for them to tell the truth back. As even though they were not questions, they were designed like questions, as they're likely to provoke a response.
Thank you. You may go ahead with your next argument.
Thank you, Your Honor. Here, Deputy Kim's statements mirrored the coercive tactics found in Finehout. For instance, Deputy Kim walked over to my client, stood only 3 feet away, and placed their hands on their holster and said statements such as, "You better make sure Duray knows everything. You don't want to jeopardize Duray's position by making them complicit in something, as well as you better lay everything out." And by implying that honesty...
I'm just going to stop you there, counsel, because I think you have done a lot of, put in a lot of intonation that is not in the record itself. So just to be clear, the court, I believe, is going to stay with what is a part of the record. I don't know that we have the evidence that the way in which the deputy spoke was the way in which you just demonstrated.
Yes, Your Honor, I understand.
Go ahead.
Thank you. By implying that honesty was necessary to protect their partner's position, Kim exerted undue pressure on Gold to speak. Considering the totality of circumstances, it is very clear that Deputy Kim's actions and statements constituted coercion and custodial interrogation, thus leading to the involuntary statement made by Gold. To admit this statement into evidence would violate my client's Fifth Amendment rights and set a dangerous precedent. Therefore, the defense would respectfully ask that the court exclude the statement to uphold the fundamental constitutional protections afforded to all individuals. Thank you.
Thank you, counsel. And the people, what is your response at this time?
Brianna Suto, on behalf of the people. The defense motion should be denied because the evidence that they seek to suppress was not obtained as the result of an interrogation.
Well, but it is true that going all the way back to Miranda versus Arizona, Chief Justice Warren wrote that coercion can arise from mental stress related to police tactics, which goes well beyond interrogation. And isn't that really what the crux of the matter or the real issue is here?
That's correct, Your Honor. Warren did state that an involuntary statement can result from mental coercion. That being said, the main issue in today's case, what this motion hinges on, is whether or not Deputy Kim's statements constituted an interrogation. Defense counsel just mentioned that it's the totality of the circumstances that we must look at. The coercive tactics that they claim Deputy Kim used are factually disputed.
Well, it is not disputed that Deputy Kim said Gold should think about how important it is for our politicians to be honest. Isn't that essentially saying you better tell the truth or your spouse's career and reputation are in jeopardy, and then that it was an opportunity to lay everything out? But wasn't that in reality the deputy wanting Gold to essentially confess?
No, Your Honor. The deputy saying that the defendant's wife was in a position of power and that it's important for politicians to be honest does not rise to the level of interrogation that the precedent in Rhode Island v. Innis sets out.
Well, what about, I apologize for interrupting, but what about the case that was cited by your opposing counsel regarding, I believe it was the Horrell case, where the defendant essentially was threatened that they would not be able to see their first and as yet unborn child if they did not confess?
Yes, Your Honor. In Brown v. Horrell, which is a Ninth Circuit court case, the law enforcement officers conditioned the defendant's ability to be with his family on his ability to comply with the officers. That's not what we see in today's case. There is no threat to the defendant's wife by Deputy Kim.
Well, let's just go back to the facts because perhaps I'm mistaken, but the court's understanding is that the officer, when questioning the defendant, told the defendant that she wanted to see Brown be able to be, or see you, i.e. Brown, be with that child and have a life, but only the truth is going to get you to that place. So essentially it was a threat to tell the truth, i.e. make a confession, which is remarkably similar to the language that was used by Deputy Kim, isn't it?
No, Your Honor. If I could invite the court's attention to the holding in Brown, it says that the detective coerced Brown into confessing by conditioning his ability to be with his child on his decision to cooperate with the police. Your Honor, that is an explicit violation of the defendant's Fifth Amendment rights within Brown. In this case, Deputy Kim does not in any way compel the defendant to speak about the case at bar. We submit that the deputy's words were simply to put the defendant at ease and to inform her that she had the opportunity to tell her wife what had happened.
But how is it going to put Ms. Gold at ease to say that they should think about how important it is for our politicians to be honest? How could that place somebody in her position at ease?
Well, Your Honor, for one, it's important to consider the circumstances surrounding these statements. This was the first time that the defendant would see her husband. As such, the husband was not aware of the circumstances that led to this arrest. It's important for the husband to know how they got here in order to obtain legal counsel, which this conversation was about. That being said, Your Honor, it is true that according to the ruling in Innis, which establishes that in order for it to be an interrogation, it must be reasonably likely to elicit an incriminating response, the deputy's intentions do not matter. It's what a reasonable person in the deputy's shoes would perceive, would expect to result from that conversation.
Isn't it also what a reasonable person in the defendant's shoes would take from that?
No, Your Honor. According to the holding in Rhode Island v. Innis, the court must consider interrogation from an objective standard from the perception of the law enforcement officer. The perception of the defendant only matters in determining custodial interrogation, or whether or not the defendant was in custody. We concede custody in today's case, Your Honor.
Well, didn't Stansbury versus California take a slightly different view of that?
No, Your Honor. Stansbury versus California specifically addresses the concern of whether or not someone is in custody. In Stansbury, the suspect was initially a witness to the crime, but later revealed incriminating information. And the court held that it does not matter whether or not the law enforcement officers believe the suspect to be guilty. It's from the perspective of the suspect. That does not have anything to do with interrogation. It addresses the concern of custody.
So your position is that the standard is really from the perspective of the defendant or the suspect when we're analyzing whether or not there is custody, but the standard is from the point of view of law enforcement when we're analyzing whether or not there's an interrogation.
Yes, Your Honor.
All right, thank you. You may proceed.
After arresting the defendant for the kidnapping of Taylor Alexander, the police Mirandized her. When she invoked, questioning ceased immediately. 2 hours later, the defendant's husband showed up at the police station demanding to speak with her. And she agreed, knowing the police would be present. It was then that she said, "I was trying to make sure the family inn could be passed down for generations."
But again, I hearken back to Arizona v. Morrow. I don't think that we have discussed this case yet, but it did arise in your opponent's argument. In that it is a very similar case factually. A spouse comes to the police station and wants to speak, and there's a recording of some statements that are made. But in that case, the court noted specifically that there was no manipulation, no direct questioning. Essentially, there was no officer conduct. So that is a stark difference from what we have in this case.
No, Your Honor. I'd like to clarify the holding in Arizona v. Morrow. They did not find that the officers did not engage in conduct, rather that they did not ask the defendant any questions. Your Honor, it's unclear based on the record whether or not the law enforcement officers talked to the defendant or engaged in any other conduct other than the tape recorder.
Well, the record that we have in front of us does not indicate that there were any statements made, and there was the finding that there was no manipulation.
That's correct, Your Honor.
Okay.
And the same is true in today's case. There was no manipulation or ploy involved in allowing the defendant to speak with his wife, with her husband.
I don't think that anybody's proposing that there was manipulation and simply letting them speak. I believe that counsel was suggesting that what was said and the way in which it was said was so coercive that it made the statements the product of coercion. Can you address that?
Yes, Your Honor. First of all, those statements are factually disputed. If I could invite the court's attention to page 30, line 28 of Deputy Kim's report.
Yes.
The deputy says, "I told Gold it was their opportunity to lay everything out for Duray." Now, we agree this is a factually disputed statement, but because the defense is the moving party in today's case, we submit that the court should take the facts in the light favorable to the non-moving party.
Well, and that to be clear, that is the statement that was made by Deputy Kim. That's Deputy Kim's version. Just above that at line 20, Deputy Kim states, "I reminded Gold that their spouse was now in a position of power in Emerald Bend, and that Gold should think about how important it is for our politicians to be honest."
That's correct, Your Honor.
Wouldn't you agree that that is a statement that is manipulative and designed to, it is analogous to the statements that were found to be coercive in the cases that have been presented to the court, in which law enforcement told suspects that they better tell the truth.
No, Your Honor. We submit that the statement, it's important for politicians to tell the truth, and referencing Duray's husband does not rise to the level of the cases that we've talked about. In Brown v. Harrell, the law enforcement officers conditioned the well-being of the defendant's loved ones. In State v. Feinheld,
Well, I don't think that they questioned suggested that the wife and the child's well-being would be at issue.
that's correct, Your Honor, I misspoke. The defendant's ability to see his family.
Thank you.
Yes, Your Honor, we submit that that statement does not rise to the level of interrogation. For that, we can turn to the Supreme Court case of Rhode Island v. Innis, in which the defendant was arrested, Mirandized, and proceeded to incriminate himself in response to statements made by the police.
But in that case, the officers weren't talking to Innis at all. In fact, the court found that it wasn't reasonable that Innis would take that as anything other than a private conversation between the officers. So there was no statement that was made to the suspect at that time.
That's correct, Your Honor. The court in Innis specifically held that those statements did not amount to an interrogation because they were not reasonably likely to elicit an incriminating response. That principle still stands. We agree that the circumstances in Innis are different from the circumstances in today's case, but it's also important to note that the statements made in Innis could be heard by the defendant, and the officers knew that. It's the fact that their words were not reasonably likely to elicit an incriminating response that made them not an interrogation.
Well, and that the court made a finding that the officers were not trying to be manipulative. They were just, at least from the court's view, trying to figure out how to get a shotgun off of the street.
No, Your Honor. The court did not find that the law enforcement officers themselves were not trying to manipulate the defendant, because the court in Innis found that it was an objective standard that determines whether or not it's an interrogation. So the law enforcement officers' intentions do not matter. That being said, the statements in Innis were found not to be manipulative because they weren't likely to elicit an incriminating response.
Thank you.
In the Supreme Court case Miranda v. Arizona, the defendant was taken into custody and interrogated without being advised of his right to silence and with no counsel present. The court held that law enforcement officers must notify arrested defendants of their Fifth Amendment rights prior to interrogating them. But what we see in today's case is analogous to United States v. Kimbrough, in which the defendant was arrested and during that arrest was permitted to speak with his mother. During that conversation, he revealed the hidden location of a firearm.
Well, the Kimbrough case is very different, isn't it? And it's also a Fourth Circuit case, so it is persuasive. But in that case, the defendant was arrested, and yes, mom was shown the drugs, but the officers didn't say anything to the mom. The officers didn't say anything to the suspect. The conversation appears to have been spontaneous with regard to mom ultimately asking questions that resulted in the suspect admitting that he had a firearm, something that couldn't possibly have been predicted. Doesn't that make it a little different than this case?
No, Your Honor, not in a way that matters in terms of the analysis. Your Honor, in Kimbrough, we submit that the conduct of the police officers was more extreme than the conduct in today's case. While it's true that they did not say anything to the defendant or to his mother, they showed the defendant's mother his drugs. The court in Kimbrough held that it was not an interrogation largely because the charge had nothing to do with firearms. In that case, The law enforcement officers could not have reasonably expected their actions to result in the discovery of a firearm because the charge in that case had nothing to do with firearms. That's what we see in today's case.
Well, the court, can you please explain that? Because it seems to the court that the statement that your opposing counsel wants to exclude has everything to do with the current case and the kidnapping and potential motive, with the reference being to the hotel.
Yes, Your Honor, we agree that after the defendant made that statement, the family inn became relevant to the investigation. Until this point, the family inn was irrelevant to Deputy Kim's investigation and to the kidnapping charge. Deputy Kim makes no indication that she believes the family inn has anything to do with this case. And as such, it's not reasonable that she would expect the defendant to talk about the family inn during this interaction.
Well, isn't it true that the entire community essentially knew about this dispute that directly bore on the inn, and that is this dispute about short-term rentals, such as the alleged victim having in this case, versus the impact on the hotel, the one hotel in town. So wasn't that a matter of common knowledge?
Yes, Your Honor. We agree that the kidnapping charge at this point had something to do with the election, but the connection between the kidnapping charge and the family inn is far more attenuated than the connection between the kidnapping charge and the election. It's not reasonable that Deputy Kim would have expected the defendant to speak about the family inn as an indication of her motive for the kidnapping charge.
Thank you. You may proceed.
What Kimbrough establishes is that law enforcement officers are not responsible, cannot be held responsible for every incriminating statement that the defendant makes. In this case, the defendant made that incriminating statement on a whim. We don't know why. Your Honor, even if you do find that Deputy Kim's conduct and words amounted to an interrogation, they didn't cause the statement. The record reveals that Deputy Kim made her statements at the beginning of the conversation, and Logan Gold incriminated herself at the end. There's too much attenuation to prove causation between the deputy's statements and the incriminating statement. For all we know, Harper Duray could have been the one who coerced that statement, or it could have been voluntary. The fact is, the defense was unable to establish causation between those 2 points.
So aside from the Kimbrough case, is there any other case that places a burden on the defense to establish causation if they find that there has been coercive conduct?
Yes, Your Honor, for that, we can turn to the California Superior Court case of People v. Musselwhite, in which the defendant's confession was determined to be voluntary because of 3 factors. First, that there was no police deception. Second, that there was no promise of leniency. And third, that even if there was deception, it did not cause the statement. If I could invite the court's attention to page 25, line 19 of the holding in Kimbrough. People v. Musselwhite. It says, the court found that the detective's false statements about the fingerprints did not cause the defendant to confess. Your Honor, in that case, because the detective's statements did not cause the confession, it was not unconstitutional. That's what we see in today's case. We still submit that the deputy's words did not amount to an interrogation.
1 minute.
But even if the court finds that they did, they didn't cause the statement. Now, Your Honor, opposing counsel mentioned the Arizona Supreme Court case of State v. Finehout. I want to be clear, Your Honor. The conduct of the police officers in State v. Finehout are different from that of today's case. In State v. Finehout, the defendant signed a Miranda waiver but said nothing incriminating.
30 seconds.
2 hours later, the police returned and continued to interrogate the defendant by telling him to tell the truth. They then added another charge to the defendant's charges of lying to the police. Your Honor, that was more coercive than what we see in today's case.
Well, in that case, the defendant also said, I ain't going to talk no more. It wasn't just a waiver and then the coercive conduct, correct? It was that the statements that the officers made and the continual questioning, even after there was an unambiguous invocation of the right to counsel, correct?
Exactly, Your Honor. The fact that the officers in State v. Finehout repeatedly told the defendant to tell the truth is what made it an interrogation. In today's case, not only do we not see advice to tell the truth, we don't see the additional coercion that State v. Finehout recognizes.
Well, didn't the holding state that a subsequent advice to tell the truth after an unambiguous invocation constitutes interrogation? Isn't that exactly what we have here?
No, Your Honor, for 2 reasons. The specific circumstances in Finehout include the police repeatedly telling the defendant to tell the truth. After an invocation, they returned. The police reinitiated the conversation, and they repeatedly told the defendant, tell the truth, tell the truth, tell the truth.
So your position is that because Deputy Kim told the defendant suspect to be honest from the record one time versus the law enforcement in Finehunt telling the defendant or suspect more than one time, that is determinative to whether or not it's coercive?
Yes, Your Honor. We do still submit that the deputy did not advise the defendant to tell the truth or any equivalent of that. In the deputy's statement, they say they have the opportunity to lay everything out.
Well, I think that Deputy Kim said Gold should think about how important it is for our politicians to be honest. Is that not the same as telling somebody to tell the truth?
No, Your Honor, because telling someone to tell the truth, especially multiple times, is an interrogation. In today's case, it's not directly alluding to the case. It's not directly compelling the defendant to talk about the case. And it does not imply that the defendant, it does not violate the defendant's prior invocation. The holding in State v. Finehout also held that the statements and actions of the law enforcement officers were unconstitutional because of the added coercion. We don't see that in today's case either.
Thank you. You may proceed.
Your Honor, because the deputy did not interrogate Ms. Gold, because her actions were not coercive, and because the defendant voluntarily made that incriminating statement, we move that you deny the defense motion and allow the evidence in. Thank you.
Thank you. And the defense response?
Yes, Your Honor. Your Honor, the prosecution says it all. Rhode Island v. Innis does not apply, as the court found that casual incidental comments between 2 officers did not amount to interrogation because they are not likely to elicit an incriminating response from the defendant. Here, Deputy Kim's targeted remarks about honesty and Duray's position were intentionally designed to provoke a response from my client, going far beyond the neutral behavior found in Innis. For these reasons, Innis should be disregarded. It's also important to look at whether the standard should be from the law enforcement officer or the suspect. And in this case, it is important to look at it from the suspect, as our case revolves around my client's mindset, and also this is what led to my client's involuntary statement.
Well, I think that what your opposing counsel said with regard to determining whether or not there is questioning, that is from the standpoint of the law enforcement officer. If I heard her correctly, that was her position as far as the authorities.
Yes, Your Honor. Where, well, it's
Do you have an authority? Do you have something that you would like the court to look at in terms of a case that establishes that the question of whether or not there is an interrogation is from the standpoint of the suspect?
Yes, Your Honor. I would like to direct you again to Brown v. Horwell, where the suspect was told by the police officer that they would not be able to see their child and or their wife if they were not to tell the truth, basically. And that was deemed that the statement was involuntary, similar to our case, as the statement was intentionally designed to provoke a response. And furthermore, that would constitute an interrogation. As an interrogation, the definition of an interrogation is very similar. Would it be reasonably likely to elicit an incriminating response from the defendant?
Thank you. You may continue.
Thank you, Your Honor. While emptying pockets and casual remarks may appear benign in isolation, the cumulative impact of Kim's actions, including standing close to the suspect, referencing Duray's political power, and placing their hands on their holster, created a coercive atmosphere.
But this was in a very small space to begin with. Is that correct? It was an 8 by 10 room, so 3 feet in that space isn't necessarily that close.
That is true, Your Honor, but when looking at the defendant's mindset, they were arrested, and then they were in a very small interrogation room, which obviously made them very anxious. And even Deputy Kim caused the anxiety to even rise further, as Deputy Kim even stood closer to the suspect. They didn't position themselves farther away from the room near the corner. They stood even closer to the suspect, which is not something necessary, and that's why it would be coercive, as it caused my client's will to be overborne.
Thank you. You may proceed.
To look at this case as an objective observer, it is clear that there was sufficient coercion and interrogation. And furthermore, these actions were far from routine. Kim's behavior imposed subtle yet significant psychological pressure, effectively transforming a neutral conversation into an interrogation's functional equivalent. This aligns with Brown v. Horwell, where even indirect suggestions tied to personal stakes were deemed coercive. The environment was coercive since it caused Gold's will to be overborne, and the environment can constitute an interrogation as Deputy Kim's statements were reasonably likely to elicit an incriminating response. For these reasons, the defense will respectfully ask that the court exclude this statement to uphold the fundamental constitutional protections afforded to all individuals. Thank you, Your Honor.
Thank you very much, counsel. Ms. Shuda.
Yes, Your Honor. Your Honor, the defense emphasizes the totality of the circumstances. I want to be clear. By doing so, they are effectively conceding that the statements alone are not enough to constitute an interrogation. So let's look at the totality of the circumstances from the perspective of a reasonable person in Deputy Kim's shoes. They're in an 8 by 10 interrogation room. They are standing 3 feet away from the defendant, which is as far away as she could from the defendant in an 8 by 10 interrogation room. She sits down, places the contents of her pocket on the table to create a casual environment. She does not place her hand on her gun. She does not ask the defendant any questions. She does not compel the defendant in any way to talk about the case at hand. Your Honor.
Well, she does state that this is her opportunity to lay it all out, and also makes a suggestion that she's going to damage the position of her spouse if she does not tell the truth.
Yes, Your Honor, it's true that Deputy Kim alludes to the defendant's spouse's position as a city council member. But I want to be clear. According to the precedent set in Miranda v. Arizona, it does not prohibit the deputy, from speaking to the defendant. It simply prohibits her from interrogating him.
And interrogation not necessarily is limited to questions.
That's correct, Your Honor. In this case, by talking about the spouse's position and by telling the defendant it's their opportunity to lay everything out for Duray, given the circumstances, this could reasonably be interpreted as informing the defendant that she has the opportunity to tell her husband what had happened. Again, Your Honor, this was the first time that the defendant was speaking with her husband after she'd been arrested. The husband was in the dark. That statement does not constitute an interrogation because it doesn't compel a reasonable person to talk about the case at bar.
Well, but talking about, you referenced the position of the officer. Certainly the officer knows how stressful it would be to have somebody sitting in an interrogation room. The officer knows how stressful it would be not to have spoken with one's spouse and then suddenly to have the spouse there. So certainly a reasonable law enforcement officer would know that this is a ripe opportunity to perhaps have some admissions.
Yes, Your Honor, exactly. The deputy took steps to ensure that this environment was less coercive. Your Honor, we agree that police environments are inherently coercive. This environment was inherently coercive, but that does not meet the standard set in Miranda v. Arizona. In order for this to be unconstitutional, according to Miranda, it must be the deputy's coercion that causes this statement. Your Honor, every police environment is coercive. In Innis, the car was coercive. But because the police's statements and actions did not add to that coercion and did not compel the defendant to talk about the case, it was not an interrogation.
Thank you.
Your Honor, opposing counsel mentioned that Rhode Island v. Innis should be disregarded. I want to be clear, the defense relies on Rhode Island v. Innis too. The precedent set in Rhode Island v. Innis establishes what an interrogation is, which is what this case hinges on. Your Honor, Rhode Island v. Innis clearly establishes that interrogation must be analyzed from an objective
30 seconds.
From the perspective of the deputy.
But again, in Rhode Island v. Innis, the officers were talking amongst each other. Nobody was telling the suspect to tell the truth. Nobody was telling the suspect to say anything or asking the suspect anything. The suspect was just riding in the car.
That's true, Your Honor, and that is an important distinction. But the standard in Innis, the precedent, it still stands. The precedent is that if a statement is not reasonably likely to elicit an incriminating response, then it's not an interrogation. Now, we submit that the circumstances in Rhode Island v. Innis are analogous to the circumstances today because of the content of the statements. That being said, the precedent of Rhode Island v. Innis is what this case hinges on.
Thank you.
Opposing counsel tried to cite Brown v. Harrell to claim that the defendant's perception matters in determining interrogation. Brown v. Harrell doesn't say that. Brown v. Harrell relies on the standards set in Innis to establish that the law enforcement officers coerce the defendant into complying.
Because of the statements suggesting they wouldn't be able to see their wife and unborn child if they didn't tell the truth. Again, there's a theme of you have to tell the truth, which is exactly what Deputy Kim did in this case.
No, Your Honor, we disagree. Deputy Kim said you have the opportunity to lay everything out. Now, even if Your Honor does accept the version of events outlined by the defendant, Deputy Kim's statement still informs the nature of those statements. Opposing counsel tried to imply that those statements were coercive. Their inflection, we don't know what the inflection of those statements were. We don't know how they may have come across during that time. What we do know is that Deputy Kim meant it as you have the opportunity to lay everything out for Duray. Your Honor, that's not an interrogation. If anything, that contributes to a less coercive environment.
Thank you.
Your Honor, because this statement was not the product of an interrogation, we move that you deny the defense motion and allow the statement in. Thank you.
Thank you. Both sides submitted at this time, or does either side wish to consult with their coaches?
No from the people.
No irregularities from the defense, Your Honor.
All right, very well. Then at this time, first of all, the court wants to commend both sides for their astute preparation and their knowledge of the facts. In these cases, with this issue, a Miranda issue, it is very factually oriented. Oftentimes, we will have testimony from people in determining whether or not there has been a voluntary statement or a violation. Better yet, we'll have recordings of statements and we can analyze inflection. We don't have that here. However, based upon the record that the court has in front of it, the court is persuaded that statements, even from Deputy Kim's standpoint and version, Gold or you should think about how important it is for our politicians to be honest, is in that context and was in that context going over a line, even in the context of the cases that have been presented. It is different than the Innis case and the Morrow case, and therefore the court is respectfully going to grant the defense motion, and the statement will be excluded.
Thank you, Your Honor.
Thank you. And at this time, I believe the teams likely need a moment to rearrange themselves.
Yes, Your Honor.
Go ahead. And does the prosecution wish to present any exhibits?
Yes, yes, Your Honor. We have an exhibit binder that's been pre-approved by opposing counsel. We'd ask that the bailiff place it on the witness stand for ease of access during the trial.
Very well. No objections?
None from the defense.
Thank you.
Thank you. And finally, we'd ask that all witnesses be constructively sequestered, barring the defendant.
Yes. So, if anybody needs to step out of the courtroom, they may do so at this time.
Oh, Your Honor, we'd ask that they are constructively sequestered.
All right, very well.
Just meaning that no witnesses will be able to testify to what they hear in court today.
All right, so noted. And at this time, the people may present their opening statement.
Julia Jackson for the people. May it please the court?
Yes.
It's early on the morning of November 11th of 2023, and the defendant, Logan Gold, has woken up in a panic. There's a debate happening later that day between the defendant's husband, Harper Duray, and his opponent, Taylor Alexander, for the last open city council seat in Emerald Bend. Stakes are high. Mr. Alexander's proposals threaten the defendant's hotel. And if Mr. Duray loses this debate, then the defendant could lose her livelihood and her legacy. For the defendant, this isn't just political, it's personal. So rather than risk Mr. Duray losing the debate, the defendant decides to take matters into her own hands. She abducts Taylor Alexander. Because of that, we've charged the defendant with kidnapping. To meet our burden, we must prove beyond a reasonable doubt that the defendant took Mr. Alexander using force and moved him to another location without his consent. Sandival, a journalist in Emerald Bend, will tell you that this election was close and that the debate was going to be decisive. He'll tell you that he saw the defendant rush into the debate hall on November 11th, out of breath, frazzled, half an hour late, go directly up to her husband and say it's all been taken care of. Taylor Alexander the victim of this kidnapping, will tell you that on November 11th, he was attacked. Hooded, bound, thrown into the trunk of a car, then driven to another location for an hour. There he was pulled out of the car, dragged down a muddy hill, tied to a metal chair, and drugged. When he was shaken awake, drugged again. The second time Mr. Alexander woke up, he found himself untied. So he called the police. Deputy Riley Kim responded to Mr. Alexander's distress call. She'll tell you that at the scene of the crime, she found blue dock line rope. And in a search of the defendant's home, found a receipt for that exact type of rope. Finally, Dr. Ray Force, the chief forensic investigator of Rowan County, will tell you that Mr. Alexander was drugged with doxylamine, a sleep aid. She'll also tell you that the tire tracks found at the scene of the crime are a match for the defendant's car. At the end of today's trial, it will be clear. The defendant couldn't risk the debate because in doing so, she would risk her hotel. Because for the defendant, this wasn't just political, it was personal. We ask that you find the defendant guilty of kidnapping. Thank you.
Thank you, counsel. And does the defense wish to present an opening statement at this time?
Yes, Your Honor. We are here today because my client has been accused of a horrible crime, a crime she would not, could not commit. The prosecution stated that Logan Gold kidnapped Taylor Alexander. However, my client is innocent. On November 11th, 2023, Logan Gold woke up earlier than usual due to nerves about her husband's final debate for the chair of City Council. Miss Gold decided that the best way to relieve her anxiety and not have it rub off on her husband was to leave the house. So she left at about 8:30 a.m. to put up campaign flyers on porches of houses around the lake. Not wanting to wake her sleeping husband, who needed as much rest as possible before his big debate, Mrs. Gold left her husband, Harper Duray, a note, alerting him of her whereabouts and that she'd be back in time for his debate later that afternoon. After passing out about a dozen flyers and stopping to speak with an old friend, CJ Costley, Mrs. Gold decided to pass out the rest of her flyers in Town Square and took a shortcut to avoid the long, winding main roads that led back into town. Unfortunately, while she was taking this shortcut, her passenger window was down, and the flyers that she was so eager to pass out blew away. Of course, Miss Gold stopped her car and picked up the litter like any good citizen would. However, when she got back in her car, it would not start. Now, car problems aren't infrequent in Miss Gold's car, seeing as it was built in 1992. So after troubleshooting the issue for about an hour, Miss Gold realized it was a starter relay issue and spent another hour making a temporary fix for the problem. Now, tired and anxious about being late to her husband's debate, Mrs. Gold rushed into town hall, only to find that the debate had not yet started. Confusion, chaos, calculated. Taylor Alexander's plan had been set in motion. While Logan Gold was out, supporting her husband in the final moments of his campaign, Taylor Alexander was busy sabotaging his opponent. However, today you will see past the gilded deception that Taylor Alexander has painted for you, because real gold shines brighter than fool's gold. Today you will hear from podcaster CJ Costley. It was through Costley's podcast that Alexander first got the idea to win over voters by faking his own kidnapping. After listening to one of Costley's episodes about a man named Wes Buffa who staged his own kidnapping, Taylor Alexander was inspired to do the same. Alexander proceeded to recreate this publicity stunt of a crime to weaponize sympathy for his own political gain. On November 11th, 2023, Taylor Alexander set his plan into motion. You will hear from Dr. Cody Palmer, who will testify that once he arrived at his rental property the day of the debate, Alexander drank a large dose of cough syrup and dozed off. After waking up, having purposely missed his big debate, Taylor Alexander groggily reached for his landline and dialed 911. knowing that he was about to give the performance of his life. Taylor Alexander's plan to tarnish Gold's reputation was calibrated. However, today you will hear from Harper Duray, Logan Gold's husband, who will testify that Gold is incapable of committing such a heinous act and that her character will shine through in the end. Finally, you will hear from Logan Gold herself, who will testify that she would never think of kidnapping her husband's competition because, other than the fact that she's not a kidnapper, Logan Gold truly believed that her husband would win, and all she needed was belief in her partner to make it through the election. Taylor Alexander, seeing the belief that Gold held for Duray, realized that he did not stand a chance. Knowing he had to act fast, Alexander decided that a fake kidnapping would both gain him the sympathy of the voters that he so desperately needed and tarnish the golden name of the competition he knew he could not beat. The prosecution has a burden to prove that Logan Gold committed this horrendous crime beyond a reasonable doubt. There are plenty of reasons to doubt the puppet show that Taylor Alexander performed for Emerald Bend on November 11th. Your Honor, we ask that you find Logan Gold not guilty. Thank you.
Thank you. And at this time, the people can call their first witness.
The people call Allie Sandival to the stand.
Calling Allie Sandival to the stand. Please raise your right hand. Do you solemnly affirm that the testimony you're about to give will faithfully and truthfully conform to the rules and facts of the mock trial competition?
I do.
Please take a seat. Please state your first and last name, spelling your last name for the record.
My name is Ollie Sandival. That's Sandoval.
Thank you.
You may proceed.
Good afternoon, Mr. Sandival.
Good afternoon.
What do you do for a living?
I'm a journalist with the Emerald Bend Daily Reporter.
Did you cover the 2023 City Council election?
I did. I interviewed both the candidates and followed the race closely.
Who were the candidates?
That would be Taylor Alexander and Harper Duray, of course.
In the course of covering the election, did you learn about the candidates' campaign positions?
I did. It really came down to vacation rentals. And while Taylor Alexander wanted to expand them here in town, Harper Duray and her wife, Logan Gold, didn't.
What was Miss Gold's involvement in the election?
She was Duray's campaign manager.
Do you see Miss Gold in court today?
I do. She's sitting at the end of the defense counsel's table wearing a black suit.
Identifying the defendant for the record.
In your reporting, did you ever witness any interactions between the defendant and Mr. Alexander?
I did.
What did you observe?
Miss Gold would start fights with Mr. Alexander.
Objection, character evidence.
Your response?
Your Honor, I'd ask opposing counsel to clarify what they're objecting to.
The witness testifying to a specific incident of the defendant being argumentative against the Taylor Alexander is character evidence because it's a specific incident.
Your Honor, may I invite the court's attention to Rule 8, prior act to prove motive, intent, knowledge, identity, or absence of mistake. In this case, we are using this act, Logan Gold starting fights with Taylor Alexander to prove motive.
Any final response?
Your Honor, I don't see how that would prove motive.
All right, submitted. The court is going to allow the evidence under Evidence Code Section 1101B, specifically on the limited issue of motive, not as to character evidence, and not, in other words, not to show that the individual has a character for kidnapping, but rather on the limited issue of motive.
Thank you, Your Honor.
You may proceed.
Did you ever hear the defendant say anything to Mr. Alexander during those fights?
I did. I heard her say that Mr. Alexander would ruin the town.
Objection, hearsay.
Your response?
Your Honor, this falls under admission by party opponent.
Any response?
I'll submit, Your Honor.
It is an admission. You may proceed.
I'd like to talk about November 11th of 2023. Where were you that day?
I was planning to cover the debate that morning.
Why did you want to attend the debate?
It was decisive. It was the last chance for Alexander or Duray to sway voters in their favor, because it was the last major event before the election.
Did you see the defendant there?
I did. But she came in late, looking frazzled, and she ran up to her husband.
Did she say anything to Mr. Duray?
She said, "It's all been taken care of."
Thank you. Nothing further, Your Honor.
Thank you. Cross-examination.
Yes, Your Honor. Good afternoon, Mr. Sandival.
Good afternoon.
You overheard my client say it's all been taken care of, correct?
That's what I heard her say.
However, you weren't part of this conversation, were you?
No, I was just listening in on what she had to say.
So you didn't know the context behind Logan Gold's remark?
No, I didn't.
Logan Gold previously dated your sibling, correct?
That's right. They had a bad breakup.
So bad that your sibling moved away?
Yes, it was unfortunate, but it was a long time ago.
And your sibling's move did sadden you, did it not?
Admittedly, it did.
You described Logan Gold as intense, correct?
Absolutely.
However, you did say that it was hard to find an unbiased source in a small town like Emerald Bend.
It is. Everyone has their own opinions on whether or not vacation rentals are good.
For example, your sibling dated a star subject of your journalism.
I don't know what you mean.
Did your sibling dated Logan Gold?
That's right.
Thank you. No further questions, Your Honor.
Any redirect?
No redirect, Your Honor. May defendant be excused?
Yes, by the defense as well.
Yes, Your Honor.
All right. Thank you so much. You may be excused and you may call your next witness.
The people call Taylor Alexander to the stand.
Calling Taylor Alexander to the stand. Please raise your right hand. Do you solemnly affirm that the testimony you're about to give will faithfully and truthfully conform to the rules and facts of the mock trial competition?
I do.
Please take a seat. Please state your first and last name, spelling your last name for the record.
My name is Taylor Alexander. Alexander.
Thank you.
May I inquire?
You may.
Good afternoon, Mr. Alexander.
Good afternoon.
I need to ask you some questions about November 11th of 2023. Do you remember that day?
I will never forget that day.
Why not?
Because I was kidnapped.
Mr. Alexander, what's the first thing you remember about that morning?
I left my house at 5:30. Someone came up behind me and threw something over my head. Then they tied my wrists behind my back and shoved me into the trunk of a car.
After you were put in that trunk, Mr. Alexander, what happened?
I was driven around for what felt like an hour. I could feel the car stop and somebody pulled me out. I was dragged down this hill and put into a room where I was tied to a chair.
Did they do anything else to you?
They made me drink this thick syrup, and then I passed out.
Did you ever see your captor's face?
No.
Did they say anything to you?
They said, everything comes back around.
Mr. Alexander, I want to talk about the election for city council. Why did you run?
Objection. There's a lack of foundation.
Overrule.
Thank you, Your Honor.
I love Emerald Bend. I've lived here my whole life, and I wanted to give something back. I thought I had an idea that would make the town better for everyone.
What was that idea?
Increasing vacation rentals, where people rent out their houses to tourists.
Did anyone oppose this idea?
Yes. Harper Duray and his wife, Logan Gold. They were directly opposed to vacation rentals.
Did they ever tell you why?
Logan did. She said that I'd ruined this town and that it'd come back around to me.
Objection. This is improper character evidence.
Your response?
Your Honor, we're not using this to show conduct in conformity, rather to establish motive. And that we're using this for a non-character purpose under the character rule.
All right, the court is going to overrule the objection. And it is also a statement of the party opponent.
Nothing further.
And cross-examination.
Yes, Your Honor. Good afternoon, Mr. Alexander.
Good afternoon.
Your only source of income as of 2023 were your vacation rentals, is that right?
Yes.
So you could say that you're depending on them, is that right?
At the time, I was.
So they were your main motivator for running for city council, correct?
No.
If Duray won, for example, you would lose your only source of income, is that right?
I wouldn't say that. Duray wanted to put restrictions on vacation rentals, but I would still have mine.
You were interviewed by CJ Costley, is that correct?
I was.
And you're aware of a podcast episode about Wes Buffa, is that right?
Yes.
And this is a man who faked his own kidnapping. You're aware?
Yes, it was horrible.
And you happened to win the Best Actor award in college, is that correct?
Yes, way back in college, I won that my senior year.
You left your main home to run, is that correct?
I'm sorry?
You left your main home to run, not your vacation home.
Yes, I go on my run every day.
And you had the keys to your vacation home in your pocket?
Yes, they were my keys for both my houses.
So you run with all of your keys in your pocket?
Yes.
When you came to, you had no lasting injuries, is that correct?
That's not true.
And what injuries did you have?
I had these marks on my wrist from when I was tied up.
You also stated that you were tied up at your legs as well, is that correct?
Yes,
But there were no ligature.
Objection, badgering may be heard.
I would just let the witness finish the first question before you answer the second question.
Of course, Your Honor.
Could you repeat the question?
You had stated that you were also bound to your legs. Is that right?
I was. I had sweatpants on though, so the ropes were over those.
But you still did not have any ligature marks on your legs. Is that correct?
Yes, that's true.
When you came to, you were able to reach the phone unassisted.
Yes, I woke up and I went into the main house and called the police.
And you were able to tell the deputy everything that happened to you coherently.
Yes,
And you had passed out 2 times.
that's true.
Your captor's voice was distorted, is that correct?
It was this whispery, gravelly voice. I couldn't make anything out about it.
So you couldn't tell the deputy whose voice you heard exactly.
I couldn't.
You knew the selection was close, correct?
Yes.
And any one change like you being kidnapped could have swayed the decision, correct?
Objection calls for speculation.
Sustained.
You didn't like Duray, did you?
I can't say I do.
And you didn't like Gold either, correct?
No. For me, it was always political, but to Gold, it seemed personal. She would always pick fights with
Objection,
me.
non-responsive.
You may respond.
Your Honor, I do believe my witness has the right to inquire further on his answer. If they'd like to establish witness control, we have no objection with that.
Your Honor, may I be heard?
You may.
The witness had answered the question, and my question was, you didn't like Logan Gold. Then they went into non-responsive by bringing up a situation in which Gold did not like them, which is not what my question was.
I'm going to overrule the objection, and so the remainder of the answer will be in.
Thank you. So you did feel passionate about this election, did you not?
I did.
Thank you. No further questions.
Anything further?
No redirect. May this witness be excused?
Yes. Thank you. And you may call your next witness.
The people call Riley Kim to the stand. But before that, we'd ask for a time check on behalf of both parties.
The prosecution has 8 minutes and 45 seconds remaining, while the defense has 5 minutes and 40 seconds remaining.
Calling Riley Kim.
Thank you, Mr. Kirk.
Please raise your right hand. Do you solemnly affirm the testimony you're about to give will faithfully and truthfully conform to the rules and facts of the mock trial competition?
I do.
Please take a seat. Please state your first and last name, stating your last name for the record.
Riley Kim, K-I-M.
Thank you.
And you may proceed.
Good afternoon, Deputy.
Good afternoon.
How long have you worked in law enforcement?
20 years. I've been serving as a sheriff's deputy in Emerald Bend since 2018.
Let's talk about November 11th of 2023. Did you respond to a 911 call that day?
I did, ma'am. At around 2:45 p.m., I received a call from Taylor Alexander. Subsequently drove to the scene of the crime, 1335 Lakeside Drive.
Upon arrival, what did you notice?
I found Mr. Alexander visibly distraught. He told me that morning at around 5:30 a.m., he had been kidnapped.
Did you collect any evidence at the scene?
I did, ma'am. I seized a pillowcase as well as some blue dock line.
Turning your attention to Exhibit D in the binder in front of you.
I'm here, ma'am.
Do you recognize this?
I do. This is the blue dock line that was seized from 1335 Lakeside Drive.
Is it fair and accurate to the best of your knowledge?
It is, ma'am.
The people offer Exhibit D.
Any objection?
None from the defense, Your Honor.
Thank you. The exhibit is admitted, and you may ask your next question.
Deputy, after collecting physical evidence at the scene, what was your next step?
I secured the scene, and then I drove Mr. Alexander to Dr. Ray Forrest's office.
And why was that?
Mr. Alexander reported being drugged during his kidnap. I wanted Dr. Forrest to run a toxicology exam.
After that toxicology exam, how did you pursue with your investigation?
I then visited the Harper Duray campaign headquarters.
Why?
The pillowcase that I seized from the scene of the crime had a reference to Harper Duray and his campaign on it. It also had the insignia of the Gold Standard Inn, which is owned by the defendant. Objection, lack of foundation as to how the deputy knows that Logan Gold owns the Gold Standard Inn.
And you can go ahead and ask foundational questions. The court will sustain the objection, and you can ask the next question.
Thank you.
Deputy, do you know what the defendant does for a living?
I do. I know that the defendant owns what's the last hotel in Emerald Bend. It's the Gold Standard Inn.
And why did you visit the Duray campaign headquarters?
Ma'am, the pillowcase that I seized from the crime that was used to blindfold Taylor Alexander during his kidnapping pointed that direction. I was following up that lead.
At that point, did you get a chance to speak to the defendant?
I did, ma'am.
Did she tell you where she was on the morning of the abduction?
She did. She explained that at around 9:30 a.m., she was passing out campaign flyers around Ambrosia Lake.
Turning your attention to Exhibit A in the binder in front of you.
I'm here, ma'am.
Are you familiar with this?
I am. This is actually a map that I created of Emerald Bend. It shows Lakeside Drive, Ambrosia Lake, and the surrounding area.
Is it fair and accurate?
It is, ma'am.
The people offer Exhibit A.
Any objection from the defense?
None from the defense, Your Honor.
Thank you. It is admitted, and you may ask your next question.
Deputy, did you search the defendant's home?
I did. On November 16th, 2023, I executed a search warrant for the defendant's home.
What, if anything, did you collect?
Ma'am, I seized a receipt that detailed the purchase of blue dock line rope. It was the same type that was used during the kidnapping of Taylor Alexander.
Objection. The receipt is hearsay.
Your response?
Your Honor, at this time we do offer Exhibit E. And to respond to that hearsay objection, we would say that this falls under a regularly conducted business activity, as it is a receipt.
And so you're offering it as a business record?
Yes, Your Honor.
Anything further from the defense?
None, Your Honor. I submit.
All right, then the objection is respectfully overruled so long as there is the proper foundation for the business record.
Thank you.
Deputy, when did you collect this receipt?
On November 16th of 2023.
And what did it detail?
Well, it detailed the purchase of blue dock line rope, which was consistent with the type that was used to kidnap Mr. Alexander.
Now, when did you arrest the defendant?
On December 4th of 2023, I arrested Logan Gold for the kidnapping of Taylor Alexander.
Thank you. Nothing further.
Cross-examination?
Yes, Your Honor. Good afternoon, Deputy Kim.
Good afternoon.
When you arrived at the scene, you never saw Mr. Alexander tied up, did you?
No, ma'am, I didn't. At that point, Mr. Alexander explained that when he awoke, he was untied.
And you had also not seen any ligature marks found on Mr. Alexander's legs, correct?
No, ma'am, I didn't find any indentations of the sort on his legs. That was consistent with his claim as he was wearing sweatpants. But I did know red inflamed marks on both of his wrists.
And Mr. Alexander was able to give a coherent story of his kidnapping, is that correct?
That's right. Mr. Alexander was distraught, but he was able to relay the information of the events of that morning.
But you had been aware that he had been drugged 2 times, is that correct?
That's what Mr. Alexander explained to me.
You stated that when you found the blue line rope at the scene, you recognized it. Is that right?
It's a type of rope that's used frequently.
And used by many citizens of Emerald Bend for boating, correct?
Well, ma'am, that's its traditional use, but I don't believe that's how it was used in today's case.
In addition to the rope, there was a variety of boating supplies on the receipt that you found. Isn't that correct?
The receipt did detail other purchases. That's right.
And aren't boating supplies something that anyone in the public could go and purchase?
Yes, ma'am, I do believe that's true.
After finding boating supplies, you found a car. Is that correct?
That's right. I also obtained a search warrant for the defendant's car.
And within that car, it had tires, correct?
That car did have tires on it. That's right.
And in one of those tires, there was a small pebble. Is that correct?
That's exactly right, ma'am.
And you're aware that Emerald Bend is a largely unpaved town, is it not?
That's correct, ma'am.
And so it's quite frequent that citizens of Emerald Bend could get pebbles stuck in their tires, isn't that right?
Objection, speculation.
Sustained.
Logan Gold provided you with an alibi the morning of her kidnapping, is that correct?
She did.
And CJ Costley corroborated this alibi, is that right?
CJ Costley was able to determine where the defendant was for 5 to 10 minutes.
So that's a yes to my question?
Well, CJ Costley was able to corroborate
Objection, non-responsive.
I'm sorry. I couldn't hear the question to hear. I mean, couldn't hear the answer to hear be non-responsive, but that is your objection. Is that correct?
I do believe that's opposing counsel's objection.
Okay. I need to hear the response. So you may proceed with your answer.
Well, as I was saying, CJ Costley was able to corroborate one portion of the defendant's alibi.
But the portion that CJ Costley did agree with aligns with Miss Gold's alibi, correct?
The 5 to 10 minutes, that's right.
And you happened to find flyers around town, correct?
That's right, ma'am. There was about 12 flyers that I found around CJ Costley's house.
Thank you. No further questions.
Anything further?
Yes, Your Honor. Deputy, please turn to Exhibit A in the binder in front of you.
I'm here, ma'am.
Now, if the defendant had an alibi for the morning of the kidnapping, why did you pursue her as a suspect?
Ma'am, CJ Costley placed the defendant right here, around his house, which is less than 6 miles from the scene of the crime. This would have allowed for more than enough time for the defendant to have kidnapped Mr. Alexander, bring him to 1335 Lakeside Drive.
Objection. This is outside the scope of my cross-examination.
May I be heard?
You may.
Yes, Your Honor, we do believe they brought up the validity of the alibi on cross-examination. We are just simply now establishing that this alibi is not credible.
Your Honor, may I be heard?
Of course.
We agree that the initial answer to the question is in response to what is brought up on cross of Miss Gold's alibi and CJ Costley's alibi, but the next steps that the deputy took in order to arrest Logan Gold is not relevant and is outside the scope of my cross-examination.
The door was opened, so the court is going to allow some latitude. It would be helpful to the fact finder. So the objection is respectfully overruled.
Thank you, Your Honor.
Deputy, how far away was the defendant spotted from the scene of the crime?
Less than 6 miles from the scene of the crime, 4 hours after initially occurred.
Thank you, Deputy. Nothing further. May this witness be excused?
May she be excused from the defense standpoint?
Yes.
All right. You may be excused. Thank you very much. And you may call your final witness.
Before proceeding, I ask for a time check on behalf of both parties.
The prosecution has 4 minutes and 4 seconds remaining, while the defense has 2 minutes and 35 seconds remaining.
And for closings?
For closings, the prosecution has 5 minutes and 18 seconds remaining, while the defense has 4 minutes and 49 seconds remaining.
Thank you. Your Honor, may I construct an enlargement of Exhibit B before proceeding?
Yes.
The people call Dr. Ray Forrest.
Call him Dr. Ray Forrest. Please raise your right hand. Do you solemnly affirm that the testimony you're about to give will faithfully and truthfully conform to the rules and facts of the mock trial competition?
I do.
Please take a seat. Please state your first and last name, spelling your last name for the record.
Ray Forrest. Forrest.
Thank you.
And you may proceed whenever you're ready.
Good afternoon, Dr. Forrest.
Good afternoon, ma'am.
What do you do for a living?
I'm the chief forensic investigator for Rowan County.
What qualifications do you have in this field?
I have my degrees in forensic sciences as well as my medical degree. I've also been a licensed pathologist for over 12 years.
How were you involved in today's case?
I was retained by the Sheriff's Department to conduct a toxicology report and a medical examination on Taylor Alexander, the victim of a kidnapping.
I want to talk about that toxicology report. What did it reveal?
Well, in Mr. Alexander's blood was an unusually high concentration of a drug called doxylamine.
What is doxylamine?
It's a sleep aid. It's commonly used in cough syrups and cold medicines.
What effect do you believe that this drug would have had on Mr. Alexander?
Given that Mr. Alexander ingested 1.5 times the standard dose, this would have rendered him unconscious. It's consistent with his recollections of his kidnapping.
Dr. Forrest, did you review any physical evidence in today's case?
Yes, I reviewed some blue dock line as well as tire tread marks found at the scene of the crime.
What did you find about that blue dock line?
The width of the blue dock line, 3/8 of an inch, matched up with ligature marks I found on Mr. Alexander's wrists. Furthermore, the fact that one of the 2 pieces of rope were present with Mr. Alexander's DNA corroborates his story of being tied up by the wrists and by the ankles.
You mentioned you also reviewed tire tracks. Have you taken any supplementary courses in tire track analysis?
I have. I've taken a 1-week seminar and I've applied this knowledge to dozens of cases.
Directing your attention to Exhibit B in the binder in front of you. What is this?
This is a comparison of the defendant's tires with tire treads found at the scene of the crime.
Is it a fair and accurate depiction?
Yes, ma'am.
The people offer Exhibit B.
Any objection?
None from the defense, Your Honor.
All right, the exhibit is admitted and you may ask your next question.
Permission for this witness to step down and make use of the enlargement, Your Honor.
Permission granted.
According to these images, what did you find about the tire tracks in today's case?
Well, the width of the tire track as well as the depth and the brand that made the impressions at the scene of the crime match up with the defendant's vehicle.
Did you notice anything specifically about the defendant's tires?
Yes. As we can see from this top image, there's a pebble lodged in one of the defendant's tires. In the second image, indicated by this yellow circle, is an indentation found in the tire treads at the scene of the crime. When we compare the width and the placement of the pebble to the indentation, they match up.
What did you conclude about the tire tracks in today's case?
1 minute.
Based on my analysis, I found that the tire treads at 1335 Lakeside Drive and the defendant's tires were a perfect match.
Thank you, Dr. Forrest. Nothing further, Your Honor.
Thank you. Cross-examination.
Yes, Your Honor. Good afternoon, Dr. Forrest.
Good afternoon.
You compared my client's tires to marks left at the scene, correct?
That's correct.
And a pebble was a common denominator between the two?
Yes, that was one of the factors, as well as the measurement and the brand of tire.
You're aware of the many unpaved roads in Emerald Bend?
That's correct.
You're also aware that Total Tire 350s are available to most anyone in Emerald Bend?
It's a tire brand, yes.
So that's a yes?
Yes.
You also examined blue docking rope found at the scene, correct?
I did.
And found only Taylor Alexander's DNA on this rope?
2 minutes.
That's right, only on one of the pieces of rope which corroborated his story.
A slip knot is a skillful knot, would you agree?
Yes.
And with enough practice, someone could tie themselves in this knot?
It's a possibility.
You found ligature marks on Taylor Alexander's wrists, correct?
That's correct during the medical examination.
No such ligature marks on Taylor Alexander's legs or ankles?
No, he was wearing sweatpants.
And after conducting your toxicology report, you found doxylamine in Taylor Alexander's bloodstream?
That's correct, at a concentration of 160 nanograms per milliliter.
Doxylamine is a sleep agent commonly found in cough syrup?
Exactly.
Cough syrup can be bought at any local pharmacy, is that correct?
That's correct.
In your professional opinion, is it possible for someone to self-administer a dose of cough syrup?
It's a possibility. It's not reasonable in today's case.
Is that a yes or no?
It's a possibility. Yes.
Thank you. No further questions, Your Honor.
Anything further?
Yes, Your Honor. Dr. Forrest, why do you believe that Mr. Alexander did not take this cough syrup himself?
Well, at the scene of the crime, the deputy never recovered any cough syrup or any container of such medicines. There's no evidence implicating Mr. Alexander self-administering this dose.
30 seconds.
Thank you. Nothing further, Your Honor. May this witness step down?
The witness may. No objection from the defense?
No, Your Honor.
All right.
And may I deconstruct the enlargement?
You may. Thank you very much. And is there going to be any further evidence from the prosecution?
No, Your Honor. With that, the people rest.
All right, the people rest. Then as soon as the exhibit is deconstructed, you may call your first witness.
The defense would like to call Logan Gold to the witness stand. Calling Logan Gold to the stand. Please raise your right hand. Do you solemnly affirm that the testimony you're about to give will faithfully and truthfully conform to the rules and facts of the mock trial competition?
I do.
Please take a seat. Please state your first and last name, spelling your last name for the record.
My name is Logan Gold, Gold.
Thank you.
And you may proceed whenever you're ready.
Thank you, Your Honor. Good morning, Miss Gold.
Good morning. Good afternoon.
Good afternoon, Miss Gold. Please introduce yourself.
My name is Logan Gold. I'm 39 years old and I'm a business owner.
Could you tell me about your business?
Well, I own the Gold Standard Inn, the only hotel in Emerald Bend. It's been in my family for generations and I cherish it a lot.
And as of 2023, were there any problems with your business?
Well, we've been having financial problems with the hotel, and then when COVID hit, it hit us hard. 2 weeks before November 11th, 2023, there was a robbery where someone stole pillowcases, sheets, cleaning supplies, things of the sort.
So have you been involved with a different job recently?
Well, in 2023, I was my husband's, Harper Duray's, assistant campaign manager for his running for a city council seat in Emerald Bend.
And did you know Mr. Duray's opponent during the race?
I did. His name is Taylor Alexander.
And did you have any sort of relationship with Mr. Alexander?
Honestly, we didn't really have much of a relationship. We've had political clashes here and there, but nothing has ever been personal.
Could you describe your morning on November 11th, 2023?
Well, I woke up pretty early because it was debate day. It's a pretty big day, and I didn't want all my anxiousness to rub off on Harper, so I decided to make myself useful and pass out election flyers around town.
Did you leave anything at the house?
I did. I left a note so Harper knew where I was.
And did you leave anything else?
I accidentally forgot my phone.
And how did handing out flyers go?
It initially went really great. I got to about 12 houses, and I got to meet up with an old friend, CJ Costley.
And after seeing Mr. Costley, where did you go?
Well, I decided that passing out flyers in town square would be best, and that's what I decided to do.
And how did that go, Miss Gold?
Well, it didn't go so well.
What happened?
I took a shortcut through an unpaved fire road that led to town square. My passenger window was down, and the election flyers were in my passenger seat when all of a sudden, all of the election flyers just flew out of my passenger seat.
And what did you do?
Well, I pulled over and I picked up the papers because I'm not a litterer.
And did anything else happen after that?
Well, when I got back into my car, it wouldn't start.
Miss Gold, is that unusual for your car?
No, my car is from 1992, and so it needs maintenance like all of the time.
So did you figure out the problem with your car?
I did. It took me an hour to figure out it was an issue with the starter relay, and then it took me another hour to create a temporary fix.
Miss Gold, did you buy a new starter relay?
I did.
Directing the witness's attention to what has been pre-marked as Exhibit F. Miss Gold, do you recognize this exhibit?
I do.
And what is it?
It's a receipt for the starter relay that I purchased from my car on November 13th, 2023.
And is this a fair and accurate depiction of the receipt that you gained?
It is.
The defense will like to move what has been pre-marked as Exhibit F into evidence.
Any objection?
No objection, Your Honor.
The exhibit is admitted, and you may ask your next question.
Thank you. Did you make it to the debate, Miss Gold?
I did, but I was 30 minutes late. I got there at 12:30.
And did you say anything to Mr. Duray?
Well, I just told Harper I'm fine. Everything's been taken care of pertaining to the election flyers that I passed out.
And what happened next?
Well, Taylor Alexander wasn't there, so at 1, the debate was canceled.
And where did you go?
We decided to go to Harper's campaign office.
And did anything of significance happen there?
Well, at around 5 p.m., we were all about to leave when a deputy came in. I think their name was Kim.
And what happened after?
Well, there was suspicion that there was a kidnapping and that someone on our campaign team had done it.
Ms. Gold, do you remember what happened on November 16th, 2023?
On November 16th, Deputy Kim obtained a search warrant for my house and my car.
And can you recall what happened on December 4th, 2023?
On December 4th, I was arrested for the kidnapping of Taylor Alexander.
Ms. Gold, did you kidnap Mr. Alexander?
No. I would never do something so inhumane, and I would never want to put my family in harm's way.
Thank you. No further questions.
Thank you. Cross-examination.
Good afternoon, Miss Gold.
Good afternoon.
You woke up on the morning of November 11th feeling anxious.
I was. It was a pretty important day. It was Harper's final debate.
That's right, you were nervous about the debate.
I was.
You knew that this debate was going to be decisive for the election.
Yes.
Let's talk about that election. You and your husband do not support vacation rentals in Emerald Bend.
We do not. They are environmentally harmful towards Emerald Bend, and we just didn't think that they would help businesses prosper.
Mr. Alexander did support these vacation rentals.
He did.
Your husband was running against Mr. Alexander.
He was.
To be clear, vacation rentals enable tourists to rent out private homes instead of hotel rooms.
Yes.
You own the only hotel in Emerald Bend.
Yes.
It's called the Gold Standard Inn.
Yes.
It's been passed down in your family for generations.
It has been, and I plan to pass it on to my children.
You said on direct that this wasn't personal for you, but the vacation rentals pose a threat to you personally.
The conversations I've had with Taylor Alexander have never been personal, but the political standards, yes.
So that's a yes to my question. Vacation rentals pose a threat to you personally.
Yes.
Let's talk about November 11th of 2023. You claim you passed out campaign flyers that day.
I did.
From around 8:30 to 10:30.
Yes.
But you can't be sure of those times.
Yeah, I didn't have my phone on me and my car's clock is broken.
In fact, your phone was turned off.
Yes, it was.
And there are no location records available for your phone on November 11th.
My phone was at home.
Is that a yes to my question?
Yes.
Let's talk about the debate. You arrived half an hour late.
I did.
When you got there, you rushed it.
I did.
You went directly up to your husband and said it's all been taken care of.
He looked nervous. I just wanted to ease him.
Is that a yes to my question?
Yes.
Mr. Alexander never showed up to that debate.
He didn't, and I don't know why.
But just 3 days later, your husband won the election.
He did, and he won it all on his own.
There's been testimony that Mr. Alexander's kidnapper said the phrase, "everything comes back around." Miss Gold, that's your catchphrase, isn't it?
It is my catchphrase, and I would never want to use it in the situation that it has been used with Taylor Alexander.
Miss Gold, "everything comes back around" is your catchphrase, correct?
It is my catchphrase.
Thank you. Nothing further, Your Honor.
Redirect.
Briefly, Your Honor. Miss Gold, is Emerald Bend a large town?
It is.
Are there a lot of businesses in Emerald Bend?
There's a lot of small businesses in Emerald Bend.
Objection, Your Honor. Relevance.
Overrule.
Thank you, Your Honor. And with those small businesses, is your hotel one of those?
Yes, it is.
And besides yourself, who else would benefit to Mr. Duray's policies?
All of small businesses.
Thank you. No further questions. May the witness be excused?
Any objection to excusing this witness?
No objection, Your Honor.
All right, the witness may be excused, and you can go and sit back with your attorneys. And you may call your next witness.
Thank you, Your Honor. Before proceeding, we would respectfully ask for a time check on behalf of both parties.
The prosecution has 7 minutes and 6 seconds remaining, while the defense has 9 minutes and 4 seconds remaining.
Thank you. The defense would like to call
Harper Duray to the witness stand.
Calling Harper Duray to the stand. Please raise your right hand. Do you solemnly affirm that the testimony you're about to give will faithfully and truthfully conform to the rules and facts of the mock trial competition?
I do.
Please take a seat. Please state your first and last name, spelling your last name for the record.
Harper Duray. Dorais.
Thank you.
And you may proceed whenever you're ready.
Thank you, Your Honor. Good afternoon, Mr. Duray.
Good afternoon.
Please introduce yourself.
I am Harper Duray. I'm 40 years old. I've lived in Emerald Bend my entire life, where I'm currently serving as a member of our local city council.
And how did you get your city council seat?
Well, I ran for it in a local election, mainly opposing vacation rentals as my platform.
Why did you run?
Against vacation rentals, specifically because these vacation rentals brought in a lot of people into our town that disrespected our natural resources and our community.
And did you have a campaign team to help you out?
Of course. I had a large campaign team to help me out, including my wife and assistant campaign manager, Logan Gold.
And how long have you been with Miss Gold?
We've been happily married 12 years now, and we even have a kid.
And how would you describe Miss Gold?
Well, she's been a compassionate spouse to me the whole way through. I've always felt supported and cared for.
And Mr. Duray, did you know your opponent during your race for the city council seat?
That would be Taylor Alexander.
And did you have any sort of relationship with Mr. Alexander?
Outside of us obviously being political opponents and interacting on the political spectrum, no, I did not have any real relationship with her.
Mr. Duray, can you explain your morning on November 11th, 2023?
I woke up around 9 a.m. and Logan was gone. She had seemingly left both her phone and a note.
Where did you go?
Well, I decided that I should head to the debate hall, so I did.
And was everyone there?
No, both Logan and Taylor Alexander were missing at the time.
And did Miss Gold ever arrive?
She did, albeit late at around 12:30. I was still glad she was able to make it there and support me any way she could, even if she was late.
And did Mr. Alexander ever arrive?
He did not.
So what was the outcome of the debate?
Well, we actually called it off around 1 p.m. because Taylor Alexander had still not arrived at that point.
And what was the outcome of the election?
I won the election on November 14th with an albeit narrow victory.
Thank you, Mr. Duray. No further questions.
Cross-examination.
Good afternoon, Mr. Duray.
Good afternoon.
Now, you love your wife.
Of course.
You wouldn't want to see her go to prison.
Yes, I would hope so.
No, it was important for your wife that you ran for city council.
It was. She first suggested the idea.
She pressured you.
She suggested the idea and stated that I should run. Ultimately, it was my choice to do so, however.
Directing you back to my question, you felt pressured by the defendant.
Yes, she wanted me to do what was best for the town.
Vacation rentals posed an economic threat to your wife's business.
I suppose they did, yes.
The Gold Standard Inn was already suffering financially. Wouldn't you agree?
It was struggling due to COVID, yes.
And she owned the last hotel in Emerald Bend.
That's correct.
I'd like to direct your attention to November 11th of 2023. When you woke up that morning, your wife was gone.
She was absent, yes.
She left her phone at home.
She did.
That's not something she normally does.
She normally does not, yes.
The next time you saw her, it was 12:30 at the debate.
That is correct. She came in 12:30, a little late, but I was thinking she was there at all.
She looked frantic. That's when she said it's all been taken care of.
More specifically, it's fine. It's all been taken care of. But yes.
You won the election 3 days later.
Correct, with a narrow victory.
Nothing from me.
Any redirect?
None needed, Your Honor. May the witness be excused?
No objection from the people?
No, Your Honor.
All right, you may be excused. Thank you so much, sir. And you may call your next witness.
Thank you, Your Honor. Before we call our next witness, the defense would like to request a time check on behalf of both parties.
The prosecution has 5 minutes and 28 seconds remaining, while the defense has 6 minutes and 50 seconds remaining.
Thank you. The defense would like to call Dr. Cody Palmer to the stand.
Calling Dr. Cody Palmer to the stand. Please raise your right hand. Do you solemnly affirm that the testimony you're about to give will faithfully and truthfully conform to the rules and facts of the mock trial competition?
I do.
Please take a seat. Please state your first and last name, spelling your last name for the record.
Cody Palmer, Palmer.
Thank you.
Good afternoon, Dr. Palmer.
Good afternoon.
Can you please describe your education and experience?
Of course. I got my undergraduate in forensics at Texas A&M University, and then I got my medical degree from University of Nevada, Las Vegas.
And how are you currently employed?
I'm a private consulting forensic investigator.
Are you aware of the toxicology report prepared by Dr. Ray Forrest?
Yes, I am.
Have you reviewed this toxicology report?
I have reviewed it.
And did you come to the same conclusions as Dr. Forrest about the doses of doxylamine found in Taylor Alexander's blood?
No, I did not.
Can you elaborate on how your conclusions differ?
In contrast to Dr. Forrest, I believe that there was one single dose administered about 12 o'clock, and it was a very large dose.
And what effect, if any, could this large dose have had on Alexander's mental state?
It would have made her groggy, incoherent, and have a debilitating effect on her cognitive functions.
As part of your work in this case, did you review a photo of blue docking rope?
Yes, I did.
Are you familiar with different kinds of knots?
I'm familiar with a multitude of knots, including slip knots.
And in your professional opinion, how likely is it that someone could tie themselves in a slip knot?
With practice, extremely likely.
How likely is it that that same person could free themselves from a slip knot?
Just as likely, simply by pulling the tail end.
Whose DNA, if any, was found on the blue docking rope?
Only Taylor Alexander's.
Are you aware of tire marks taken from the scene?
Yes, I am aware of tire marks at the scene.
Can you describe these tire marks?
The tire marks were about 5/32 of an inch deep and were made by a Total Tire 350 tire.
Drawing your attention to what has been pre-marked as Exhibit B, can you describe what you see?
Yes, these are the aforementioned tire marks as well as Logan Gold's tires.
And after reviewing this exhibit, what conclusions can you draw?
I cannot conclude that Logan Gold's tires left these marks.
What makes you say that?
Well, Logan Gold's tires have a tire depth of around 6/32 of an inch, whereas the tire marks themselves are only 5/32 of an inch, which is a 20% discrepancy.
Anything else?
Yes. Emerald Bend is an unpaved town, which means that there are a multitude of places where you could get a pebble stuck in your tire, as well as the fact that Total Tire 350 is a very common tire.
Thank you. No further questions, Your Honor.
Thank you. Cross-examination?
Let's talk about those tire tracks. Now, you'd agree that the tire tracks found at the scene of the crime and the defendant's tires are from the same brand.
Yes, the Total Tire 350s.
Now, you just said on direct examination that that's a common brand of tire.
Yes, I did.
Nowhere in your statement do you say that.
Yes. No, I do not say that in my statement.
Now, you agree with Dr. Forrest that the tire tracks found at the scene of the crime were 5/32 of an inch.
Yes, I do.
But you disagree that the defendant's tire tracks were that same margin.
Yes, I believe they were 6/32 of an inch, which is a 20% discrepancy.
Well, I want to be clear, you approximated your measurements.
Yes, I did.
Now, let's talk about the doxylamine you mentioned on direct.
Okay.
Now, you believe that that amount of doxylamine Mr. Alexander ingested could have impaired his memory?
Yes, I do.
But you can't say that for certain, can you?
As I was not there, I cannot say for that for certain, but neither was Ray Forrest.
Exactly, you weren't there.
Yes, that's what I've said.
Dr. Forrest was.
Not while she gave her testimony.
Well, Dr. Forrest examined Mr. Alexander, isn't that?
Yes, that is true.
Now let's talk about what was found in the defendant's truck. You're aware that oxalic acid was present all over the defendant's truck?
Yes, it's a cleaning supply.
That's right, it removes stains.
Yes.
And you're aware that Mr. Alexander claims he was transported in a truck?
Yes.
Nothing from.
Any redirect?
Briefly, Your Honor. Dr. Palmer, are you confident in your findings?
Extremely.
Thank you. No further questions, Your Honor.
And any objection to this witness being excused?
No, Your Honor.
All right, witness may be excused. Thank you, Dr. Palmer. And you may call your next witness.
Your Honor, the defense would like to call C.J. Costley to the witness stand.
Calling C.J. Costley. Please raise your right hand. Do you solemnly affirm that the testimony you're about to give will faithfully and truthfully conform to the rules and facts of the mock trial competition?
I do.
Please take a seat. Please state your first and last name, spelling your last name for the record.
CJ Costley, Costly.
Thank you.
And you may proceed whenever you're ready.
Thank you. Good afternoon, Mr. Costley.
Good afternoon.
What exactly do you do for work?
Well, I'm a local podcaster based right here out of Emerald Bend.
And what do you cover on your podcast?
I like to cover local politics, some true crime, and a bit of small town drama.
Are you aware of the local election for city council?
Yes, I am.
Have you been covering this election?
Yes, I have.
And as part of your coverage, have you interviewed either of the candidates?
Yes, I've interviewed both candidates in separate occasions.
And did anything, if at all, stick out about these interviews?
Well, I noticed a lot of expressed animosity coming from Taylor Alexander.
Can you elaborate on these interviews with Taylor Alexander?
Yes, I like to ask relevant political questions, such as about their campaign or their policies, and Taylor Alexander repeatedly replied with personal and political jabs towards Duray and his wife, Logan Gold.
And did you have any plans on November 11th, 2023?
Yes, I was planning on attending their final debate.
Did you see anybody before you made your way to town hall?
Yes, at around 9:30 or so, I saw Logan Gold putting out a flyer on my porch, and we chatted for a while.
Did you ever make it to this debate later?
Yes, I did.
How did the debate go?
Well, it never happened because Taylor Alexander failed to show up, which was quite unusual.
In the days following your debate, did you do anything regarding your podcast?
I re-listened to all my old episodes to see if I could find anything of significance.
And what, if anything, did you find while re-listening?
Well, all the expressed animosity from Taylor Alexander just really set in.
Anything else?
Yes, I noticed that I recommended Alexander listen to one of my episodes about West Buffa.
Who is West Buffa?
West Buffa is a man from Crescent City who faked his own kidnapping.
Thank you. No further questions, Your Honor.
Cross-examination.
Before proceeding, Your Honor, may I have a moment to confer with co-counsel?
You may.
Good afternoon, Mr. Costley.
Good afternoon.
I'd like to talk about your podcast.
Okay.
You're invested in the idea that Mr. Alexander kidnapped himself.
Yes, I am. That is what I believe.
You said on direct that you told Mr. Alexander to listen to the West Buffa case.
Yes, I did. I wanted to make him familiar with the podcast as it was his first time.
But you don't know if Mr. Alexander ever listened to that episode?
He never told me if he did, but I just assumed he did.
So that's a yes to my question. You don't know if Mr. Alexander ever listened to that episode.
I do not know definitively.
You broadcasted your theory that Mr. Alexander kidnapped himself.
Yes.
And your listenership subsequently took off.
Yes, but I have no way to predict that.
Is that a yes to my question?
Yes.
On direct, you also said that on November 11th, you saw the defendant at 9:30.
Yes, around that time.
But you only saw the defendant for 5 to 10 minutes?
Yeah, they had something to do, so I didn't want to keep her too long.
Direct your attention to Exhibit A in the binder in front of you.
Yes.
This is a map of Emerald Bend.
Yes, it is.
Your house is on that map.
Yes, it is.
You saw the defendant at your house.
Yes.
The 1335 Lakeside Drive is also on that map.
Yes, it is.
Your house is less than 6 miles from 1335 Lakeside Drive.
Yes.
Thank you. Nothing further, Your Honor.
Thank you. Any redirect?
None needed. May this witness be excused?
Yes, if there's no objection.
No objection, Your Honor.
All right, you may be excused. Thank you very much.
At this time, the defense rests.
All right, the defense rests. The people have rested. Are the people ready to present their closing?
Yes, Your Honor.
You may proceed.
I want to take you back to Ali Sandival's testimony on the stand today. He described seeing the defendant rush into the debate on November 11th of 2023. He told us the defendant looked frazzled. That's when she said, "It's all been taken care of." Your Honor, notice what she didn't say. She didn't question why the debate hadn't started. She didn't ask where Mr. Alexander was. Because she knew. Mr. Alexander was right where she left him. Drugged and unconscious. So why did the defendant kidnap Mr. Alexander? Because if he won that election and that debate, the defendant stood to lose her livelihood and her legacy. And for her, this wasn't just political. Your Honor, it was personal. That's why we've charged Logan Gold with kidnapping in violation of California Penal Code Section 207A. To meet our burden beyond a reasonable doubt, we must have established that the defendant kidnapped Mr. Alexander and transported him without his consent. We've met that burden. Let's talk about the facts. We know the Gold Standard Inn was suffering financially due to an expansion and rental properties. An expansion that would only increase if Mr. Alexander was elected. We know if Mr. Alexander was elected, the defendant thought he would ruin the town, but the truth is the only thing we'd ruin is the defendant's business. So on the morning of November 11th, she drove to his home where she knew he'd be going for his daily run. As she attacked him, shoved her in the trunk of her car, and transported her to 1335 Lakeside Drive in her truck. The physical and forensic evidence supports our case, Your Honor. Because in the defendant's trunk, oxalic acid was found. A powerful cleaning agent all over the trunk of her car. The defense tried to tell you it was just a coincidence. But we know that's not reasonable. Because it was that trunk that the defendant transported Mr. Alexander. Dr. Forrest noted ligature marks on his wrists. Ligature marks that measure 3/8 of an inch. The same width as the rope purchased by the defendant not even 5 days before the kidnapping occurred. And at the scene of the crime, there were tire tracks. Those tire tracks were a match for the defendant's vehicle. The defense tried to tell you through their expert that Total Tire 350s are a common brand of tire. He was impeached on the stand today, Your Honor. He wasn't testifying to the evidence, he was testifying for the defense. But he did concede that the tires found at the scene of the crime and the defendant's tires are the same brand. So what does the defense have to say to this mountain of evidence, Your Honor? They offer you the word of C.J. Costley as evidence that the defendant was nowhere near the scene of the crime. But Miss Costley saw the defendant for a grand total of 10 minutes. Your Honor, that is an incomplete alibi, if an alibi at all. If there's any doubt in the court's mind as to the whereabouts of the defendant on the morning of the abduction, we need only look to what she said when she arrived late to that debate. She said, "It's all been taken care of," and Your Honor, she meant it. Taylor Alexander. He wasn't going to be a problem anymore. Today, we prove beyond a reasonable doubt that the defendant was at the scene of the crime, abducted Mr. Alexander by force, and transported him without his consent. But not only that, we've proved that the defendant had the means, motive, and opportunity to commit this crime. We proved that the defendant couldn't risk losing her livelihood or her legacy, so she kidnapped Mr. Alexander. Find her guilty. Thank you.
Thank you. Defense.
Yes, Your Honor. May I begin?
Please.
The prosecution bears the burden of proof, but today, Your Honor, the defense has exposed the truth, because real gold shines brighter than fool's gold. Taylor Alexander, the ex-actor, desperate for an election win for his only source of income, vacation rentals. The evidence you've heard today does not point to Miss Gold, but points to Taylor Alexander, whose supposed kidnapping was nothing more than an elaborate scheme designed to manipulate this election and drag the good names of Logan Gold and Harper Duray. Today, you've heard true witness testimony from Logan Gold, Harper Duray, Dr. Cody Palmer, and CJ Costley. Podcaster CJ Costley brought the court's attention to a recent episode about Wes Buffa, who faked his own kidnapping. Costley recommended this episode, and Alexander was inspired. He set out at 5:30 to commence his story. In the early morning, while Mr. Alexander was preparing his kidnapping, Logan Gold was merely handing out flyers at 8 a.m. in support of her spouse. As CJ Costley confirmed, and as Deputy Kim confirmed after finding flyers around Emerald Lake. And as Taylor Alexander was leaving his house conveniently with his vacation rental keys, Logan Gold was pulled over on the side of the road with a broken down car, as proven by the starter relay receipt. And as Taylor Alexander was preparing his dosage of cough syrup, which he knew would only make him fall asleep, Miss Gold was spending an hour fixing her car. Your Honor, you've heard today that Dr. Ray Forrest say that a slip knot would be difficult to tie yourself with. However, Mr. Alexander did not need the slip knot because no one saw him tied up. He could have just used the rope and rubbed his wrists so that ligature marks could be visible to Deputy Kim. You've also heard today that Dr. Cody Palmer explained that Mr. Alexander's speech and memory should have been incoherent due to the cough syrup dosage, but he could give his testimony in full to Deputy Kim because he planned everything he wanted to say. Your Honor, the only forensic testimony that the prosecution offers is weak at best and inconclusive at worst. A single pebble in a single tire on a single tire track that could have been made by any other similar vehicle does not place Logan Gold to the scene. No other evidence was found linking Logan Gold besides a stolen pillowcase that's open to anyone in the public, including Taylor Alexander. And what else is open to anyone in the public? Cough syrup from a pharmacy and boating rope from a supply store. You've heard today that only Alexander's prints were the ones found at the crime scene. The facts reveal inconsistencies and motives that paint a different picture than what the prosecution suggests. Remember, Taylor Alexander had every reason to manufacture this incident. He knew it was possible through the podcast. He had the acting ability. He desperately needed the money, and he had just the right of hatred towards his opponents.
1 minute.
Knowing that his campaign was failing to gain traction and sensing defeat, he decided to weaponize sympathy to tarnish the Golden Duray campaign. By staging this incident, Alexander took an opportunity to seize headlines to create doubt around Logan Gold's character. Logan Gold, a business owner, a wife,
and a mother is innocent, we ask that you see through this gilded deception that the prosecution claims is the truth and deliver a verdict of not guilty. Thank you.
Thank you. And rebuttal?
Now, the defense just got up here and told you that Mr. Alexander faked his own kidnapping. But that's not a reasonable interpretation of the evidence, Your Honor. How do they suggest that Taylor Alexander got to 1335 Lakeside Drive? Did he walk? The tire tracks of the defendant's vehicle were found at the scene, not his. And we know it takes at least an hour to get from town to 1335 Lakeside Drive.
30 seconds.
It's not reasonable that Mr. Alexander rubbed his wrists together so hard that ligature marks appear. It's not reasonable that he literally dragged himself through the mud to gain sympathy votes. What is reasonable is that the defendant stood to lose her livelihood and her legacy if Mr. Alexander won that election. It's reasonable that she kidnapped Mr. Alexander. Find her guilty. Thank you.
Thank you. Defense?
May I begin?
Please.
Your Honor, the defense's burden is not to prove that Taylor Alexander committed a fake kidnapping. We must prove that Logan Gold is not guilty, and the prosecution has the burden of proof beyond a reasonable doubt. The defense's case brought reasonable doubt. Everything, all forensic testimony, has been refuted as it's open to anyone in the public and has discrepancies between experts. Your Honor, Logan Gold is not guilty because of the reasonable conclusions that don't point her to the scene or the kidnapping. We ask that you find Miss Gold not guilty.
Thank you. And before I rule, does either side wish to confer with their attorney coaches or teacher coaches? And same for the defense. Would you like to confer?
No irregularities from the people, Your Honor.
No irregularities from the defense.
All right. This has been a very close and difficult case for everyone. Both sides have done an outstanding job of presenting their evidence and making their arguments, making it very difficult for the court, and wishing that the court had 11 other jurors to help decide this case, but we do not. The court finds that there is significant circumstantial evidence on both sides here. Certainly, it stretches reasonableness to believe that Alexander planned their own kidnapping. However, there is some evidence to support that theory, and ultimately, as defense pointed out in their rebuttal, although that is one theory, all they have to do is raise a reasonable doubt. So a few things that the court has considered, although not dispositive, are the lack of any DNA evidence other than that of the alleged victim on the ropes, and ultimately, really, it boils down to the credibility of the witnesses. And here, although both witnesses were credible, again, the burden is with the people, and the court did find that Ms. Gold was very genuine and respectful in all of her responses and testimony. Therefore, the court is going to find that the people have not met their burden. It's a very high burden of beyond a reasonable doubt. And Ms. Gold will be discharged.
Thank you, Your Honor.